Okay, let's unpack this. Imagine you're a general contractor. It's high stakes, commercial construction. You're scrambling to put together a massive bid, maybe $317,000 for a school project, deadlines in an hour. Everything hinges on getting the lowest price from your subs, maybe for the paving work. You get a call. It's a low number, say just over $7,000. You trust it. You have to, right? You plug it into your main bid, list that sub, hit send. You're legally bound, and guess what? You win. Great news. For a minute. Then the phone rings the next morning. The sub says, sorry, big mistake on our end. Price is actually double. That right there, that's the nightmare scenario. And it throws us right into today's deep dive. When does a simple verbal offer, one that hasn't been formally accepted, become, well, ironclad, irrevocable?
Exactly. And if we connect this to the bigger picture, what we're looking for is the legal mechanism, the bridge, that turns a maybe revocable offer into a firm commitment. Standard contract law usually needs that offer, acceptance, and consideration, the quid pro quo. But in fast-paced bidding like this, that formal back and forth often just doesn't happen in time.
Right, things move too fast.
So our mission today is to explore how reliance, just relying on the promise, can sometimes step in and take the place of that consideration. We're moving into the territory of fairness, of equity. We're talking about promissory estoppel, specifically Restatement Section 90. And we'll use a really key case, Drennan v. Star Paving Co., to show exactly how courts break this down, element by element.
Perfect. So Section 90 is like a legal safety net, yeah. For situations that just feel fundamentally unfair, even if you don't have a perfect textbook contract. So let's start there. Why didn't traditional contract law work for Drennan, the general contractor in our example? If Star Paving's low bid was just an offer, why couldn't they just say, never mind, the next day before Drennan formally accepted it?
Well, they couldn't because of promissory estoppel. Put simply, the doctrine says if you make a promise, and you should reasonably expect someone to rely on it, and they do rely on it, significantly to their detriment, then that promise can become legally binding, even without consideration, if that's the only way to prevent injustice.
Okay, so reliance itself becomes the trigger.
Precisely. The Restatement Section 90 gives us the specific test. It's got three main parts. One, there has to be a promise that the promiser, the one making the promise, should reasonably expect to cause the other party to act or not act. Two, the promise actually causes that action or forbearance, and it has to be definite and substantial, real consequences. And three, the promise is only binding if enforcing it is the only way to avoid injustice.
Got it. So it shifts the focus from the bargain to the harm caused by breaking the promise. Let's apply this. We need to dig into the case that really defined this area. Drennan v. Star Paving Co. First, what are the legally dispositive facts?
Okay, the key facts. Drennan was the general contractor bidding on the Monte Vista school job. Right before the deadline, he gets this phone bid from Star Paving for the paving work, $7,131.60. It was the lowest. Drennan uses that exact number, submits his overall bid listing Star Paving, and he wins the main contract. He's locked in. Next morning, Star Paving calls. They say they made a mistake, a big one, and they won't do the job for less than $15,000. Drennan eventually had to hire another company, L&H Paving, for almost $11,000. So he ended up losing $3,870 because Star Paving backed out.
Ouch. Okay, what was the core legal issue the court had to decide?
The central question was this. Did Drennan's significant detrimental reliance on Star Paving's bid make that bid irrevocable under promissory estoppel, even though there was no formal consideration or bilateral contract yet?
Makes sense. So what rule of law did the court apply? Can you state the full rule again, maybe highlighting its elements and how reliance fits in?
Sure. The court applied Restatement Section 90, promissory estoppel, and the key idea here is that Drennan's reliance, changing his position based on the bid, effectively substitutes for the consideration you normally need in a contract. It's the reason the law holds Star Paving to their word. And the elements, again, 1, reasonable expectation reliance, 2, actual substantial reliance, and 3, injustice can only be avoided by enforcement.
Thank you. That's clear. Now for the court's elemental analysis. Let's walk through this step by step, just like a court would. How did the court apply the first element, that the promise was reasonably expected to induce definite and substantial action?
Right. The court looked at the context commercial bidding. Element 1 basically asks, should Star Paving have known Drennan would use their number? The court said, absolutely. Star Paving's bid wasn't just a quote, it was a promise to do the work for that price if Drennan got the job. And crucially, the court pointed out Star Paving had a direct stake in Drennan relying on their bid. The lower their bid, the better Drennan's chance of winning the main contract, which in turn meant Star Paving got the subcontract. It served their interest too. So the court concluded that Drennan using the bid in his master bid was the definite and substantial action Star Paving should have expected.
Okay, but hold on. Isn't every sub hoping their bid gets used? Why does that hope suddenly become legally binding here? What makes it different?
Ah, good question. It's the substantial character part and the nature of the reliance. The court isn't just looking at hope, it's looking at the fact that once Drennan submitted his bid based on Star's number, he was locked in. He couldn't just, swap it out. Star Paving wasn't just inviting Drennan to consider their price. They were inviting him to commit himself legally based on that price. That's the key difference.
Okay, that distinction is important. It's about inducing that binding commitment. Now, what about the second element, the actual inducement of that action? Was Drennan actually induced?
This part is mostly about the facts. Drennan testified clearly. He received Star's bid. It was the lowest. He listed it, calculated his final price using it, and submitted the binding overall bid naming Star. So by winning the main contract, Drennan legally bound himself to the school district, relying entirely on Star Paving's terms for the paving portion. The court found this element was clearly met. The bid directly caused Drennan to take that substantial binding action. His exposure was real.
Right. And the final element, whether injustice can only be avoided by enforcement. This is often where defenses come up. Star Paving's big defense was mistake, right? It's that the bid was wrong, so they should be able to revoke it. How did the court handle that within this injustice analysis?
Exactly. This is where the court weighs the equities. Who should eat the loss from the mistake? The court laid out a kind of sub-rule for mistake in this context. A mistake lets you off the hook only if the other party Drennan knew or reasonably should have known it was a mistake. And critically, only if Drennan could be put back in the position he was in before relying the status quo.
So did Drennan know, or should he have known?
Drennan testified the bid. While low, wasn't unbelievably low for that specific area, Lancaster, desert region, competitive market. He said variances of 160% weren't unheard of. So the court found Drennan had no reason to suspect an error. That takes care of the first part of the mistake rule. And for the second part, the status quo. No way. Drennan was already legally bound to the school district on the main contract. He couldn't just walk away.
So the court couldn't put him back where he started.
Correct. Which leads to the policy conclusion. The loss has to fall on the party who made the mistake, especially when they were in the best position to prevent it. That was Star Paving. Drennan acted reasonably, acted promptly once he won the bid, forcing him to absorb that $3,817 loss because of Star Paving's internal calculation error. That would be the injustice Section 90 is designed to prevent.
Okay, that analysis makes sense. It ties the mistake defense directly into the fairness element. So after analyzing all the elements and the defense, what was the court's final conclusion?
The court affirmed the lower court's judgment for Drennan. It held that Drennan's reasonable, detrimental reliance essentially created an implied promise within Star Paving's offer. A subsidiary promise, if you will, not to revoke the main offer once Drennan had relied on it in this substantial way. Promissory estoppel enforced that implied promise, making the offer irrevocable for a reasonable time.
An implied promise not to revoke enforced by reliance. Okay. Now this is where it gets really interesting, I think. To really make this stick, let's push the boundaries with a hypothetical. Test that third element, injustice, maybe with something unique. Okay, imagine a contractor bidding on that same school, but this time they rely on a sub-bid for a very specific, unique, custom-cut slab of granite for the main entrance. It's one of a kind, maybe heavily discounted. The contractor uses this granite bid, wins the main contract. Great. Next day, the granite sub calls, whoops, massive miscalculation on the cutting costs. It's going to be 5 times the price. Now, if the contractor absolutely cannot find a comparable slab anywhere, the project gets delayed, they face huge daily penalties. Where does the loss fall then? And why does this unique situation really highlight the injustice part of Section 90?
Oh, that's a powerful hypothetical. The loss, again, falls squarely on the mistaken subcontractor, the granite supplier. The uniqueness of the granite makes the reliance even more definite and the harm potentially catastrophic. It's not just about finding another supplier at a higher price. It might be impossible. The contractor can't mitigate easily, maybe not at all. They're facing not just increased costs, but potentially project failure and massive liquidated damages for delay.
So the inability to mitigate really drives home the injustice.
Absolutely. When the relying party, the contractor, changes their position so drastically based on the promise, and they acted reasonably, they become the innocent party who stands to suffer disproportionately. Applying Section 90 here prevents the sub from basically shifting the catastrophic consequences of their own error onto the contractor. Not enforcing the promise would lead to a truly unjust, potentially ruinous outcome for the contractor. That's the core of the injustice element.
Okay, that visceral example helps nail it down. So let's synthesize this. For someone facing this issue, maybe on an exam, maybe in practice, what's the takeaway? How do you structure the analysis based on Drennan?
Right, this is the crucial framework. If you spot a scenario with a general contractor relying on an unaccepted subbid, here's your step-by-step diagnostic checklist. Step 1, traditional contract check. Always start here. Is there an actual bilateral contract? Was there offer, acceptance before revocation, and consideration? Usually in these Drennan-type situations, the answer is no. If not, proceed. Step 2, apply promissory estoppel. Section 90. Frame the issue correctly. You're not looking for a standard contract. You're arguing the sub's offer contained an implied subsidiary promise not to revoke, enforced by the GC's reliance. Step 3. Test the 3 elements of Section 90. Go through them one by one. Was reliance by the GC reasonable and foreseeable to the sub? Usually yes in bidding. Did the GC actually rely in a definite and substantial way? Using the bid in their own binding prime did is the classic example. Is enforcement necessary to prevent injustice? Consider the harm to the GC who made the error, possibility of status quo. Step 4. Check the 2 big Drennan caveats or defenses. These are critical checks that could defeat the claim. Knowledge of mistake. Did the GC know, or should they reasonably have known, that the sub's bid was mistaken? If the bid was wildly out of line, reliance might be unreasonable. No Section 90 protection then. Prompt acceptance. Did the GC act promptly to accept the sub's bid after winning the prime contract? Unreasonable delay, maybe trying to bid shop, could cause the sub's offer to lapse. Again, no Section 90.
That's a really practical checklist. It covers the core doctrine and the key defenses laid out in Drennan. It shows how reliance really can act like consideration in these fast-moving commercial situations, forcing accountability.
It does, but it also leaves us with a final thought to chew on. Think about Drennan. Star Paving's offer was silent on revocability. What if? What if their bid had explicitly stated, maybe in bold print, this offer is revocable at any time until formal written acceptance is received by Star Paving? Would the court still have used promissory estoppel to find an implied promise not to revoke? Or would that express language, that freedom of contract principle, trump the equitable concerns of Section 90? That's a fascinating tension, isn't it? Where does fairness stop and express terms take over? Something to think about.